Good evening, friends. Important video. And this is on instruction number 5 2023 dated 13th of December 2023. Very interesting. We have seen that field formation, whenever they are initiating any investigation, inspection, search, they always invoke extended time period for issuance of so-called notice, and obviously they invoke 74 subsection 1 on the pretext then there is a fraud, willful misstatement, suppression of fact. Quite obvious. हमने देखा है अगर डिपार्टमेंट ने कोई भी इन्वेस्टिगेशन, इंस्पेक्शन, सर्च इनिशिएट करते हैं तो एक्सटेंडेड टाइम पीरियड इन्वोक करते हैं अंडर सेक्शन 74 सबसेक्शन 1, और उनका प्रीटेक्स्ट क्या होता है कि देयर इज अ फ्रॉड, देयर इज विलफुल मिसस्टेटमेंट और सप्रेशन ऑफ फैक्ट. कई बार देयर इज अ केस ऑफ नॉन पेमेंट ऑफ टैक्सेस, maybe bona fide ground, maybe on interpretation, maybe on classification. There is no intention to evade taxes. Of course, there is non-payment for the region, different interpretation by the taxpayer and by the department. Classification issue. Can it be a subject matter of fraud, willful misstatement, suppression of fact? Can department in mechanical manner invoke extended time period for issuance of so-called notice under section 74 subsection 1 of CGST Act? This instruction is on different context but helping all of us together, which you can cite when you are defending a case where is only interpretation issue and there is no intention to evade taxes. Non-payment only because interpretation. There is no intention to evade taxes. So this interpretation is on different context. What is that context? Listen carefully. We know recently Supreme Court in the case of Northern Operating System has held when employee of foreign entity is being sent on deputation to Indian firm or Indian entity, it is supply of manpower services and service tax leviable. And we have seen that all investigating agency has initiated pan-India, field formation has initiated pan-India proceedings, and they are demanding even GST on such deputation of employees by foreign entity to Indian entity under supply of manpower services. They are demanding GST and they are invoking section 74 subsection 1, extended time period. On the pretext there is a fraud, willful misstatement or suppression of fact. It is mechanical manner, but this instruction is helping us out. Read this instruction which is given in a description box through a newsletter. It is clearly citing one Supreme Court judgment, Fiat India Limited. And this judgment is clearly saying they have picked up one specific clause from the Supreme Court judgment and saying that field formation should not initiate their proceedings in mechanical manner. They must look at the fact of each case. Comparison need to be drawn. What was the fact in the case of Northern Operating System versus proceedings they want to initiate. So fact of the case is important to analyze, to determine whether liability exists. Close similarity does not mean that both the cases are same, because a single significant details may alter fact of each case. Close similarity, I'm repeating these terms, very interesting. Close similarity does not mean both are same. A single significant detail may alter one case to another. So we have to look at the fact of the case for initiating any action, and field formation should not do mechanically. So very interesting that we are finding on supply of manpower services, service tax liable as per Northern Operating System, which is being applied in GST, cannot be applied mechanically. Government has to look at the fact of each case in detail. Close similarity should not be the basis. A single significant detail may alter one case to another. So very interesting, and they have said that 74(1) subsection 1, invocation of extended time period should not be done mechanical manner. Even non-payment, department always allege fraud, willful misstatement, suppression of fact is incorrect. This instruction is saying, instruction number 5, 2023, dated 13 December 2023. Interesting one. So maybe this relevant para, that non-payment will always be fraud? No. So interestingly, I can draw reference to all of you that for power to arrest under section 69, right? When commissioner can pass an order for arresting any person if he is engaged or committed in any of the specified offense under section 132 subsection 1 clause A to clause D. These section, when read with section 132, always talks about there should be intention to evade taxes. One of the client met me in the past, and his issue was only on classification. As per classification, their interpretation was it is 12% leviable, but department कहता था it is 18% chargeable. Interpretation. And department was giving threatening to the taxpayer, saying that you pay up the liability 6%, otherwise we are going to arrest you, because differential demand is more than 5 crore. We will arrest you. In my humble submission, and this is what this instruction is endorsing, non-payment will not always be fraud, willful misstatement, or suppression of fact. Department has to prove that there is intention to evade taxes. When interpretation on classification and two views are possible, how come this matter be intention to evade taxes? Taxpayer कह रहा है 12% लगेगा, department कह रहा है 18% लगेगा. There is no intention to evade taxes. आप arrest की धमकी under section 69 read with section 132, prosecution proceedings 74 हम invoke करेंगे, extended time period, not permissible, and that is what this instruction is helping. So instruction coming from the context of northern operating system, but also there is a specific para which is talking about that mechanically field formation should not invoke 74 subsection 1 of CGST Act. Interesting one. All the details as per the newsletter and this particular instruction is being given in the description box for ease of understanding. Thanks for watching. Stay tuned. Thank you very much.